At least on the side of the defense, I'm talking about the A1. The law enjoins the state in prosecuting a matter to make available all evidence in their possession to an accused person. It's a rule of law. There are no flexibilities with it. This is a clear case where there was a lot of evidence they took from the accused person and they refused to deliver those bits and pieces of documentary evidence to the accused person. It's one of the several issues that we address the court upon. This got nothing to do with a substantive matter. In law, is both substantive and procedural. And in terms of procedure, if there are certain lapses, there are certain breaches with clear rules of procedure, it always inures to the benefit of the accused person. I heard the judge address the issue by dismissing it and suggesting that the accused person could have applied to the court for those documents that are released to him. But it's not the business of an accused person to apply to the court for that, for those things to be released to him. It's as simple as that. The real issue is whether indeed there was such evidence and whether such evidence, if it had come in, could have assisted the accused person. This was our point. So it is irrelevant with due respect to the court. It's irrelevant in our view whether indeed we could have applied or couldn't have applied. Exculpatory evidence, exculpatory is favorable evidence, anything. Because see, the thing about law, the thing about criminal prosecution is that an accused person need not even say anything at all. An accused person can stand mute of the court. And it's the duty of the prosecutor to prove their case beyond reasonable doubt. Case is not as simple as that. It's a case where the prosecution specifically and deliberately, there's a lot of evidence on the record. And indeed, the prosecution was specifically accused, not only by one witness, but about 2 or 3 witnesses, of deliberately hiding evidence from the court. And the evidence is quite clear. The issue is, if the prosecutor has a good case, why withhold evidence from the court? It's the duty of the prosecutor to put every evidence, whether favorable or unfavorable to the prosecution, before the court. An accused person doesn't have that burden in law. The prosecution and the defense can agree, negotiate that, okay, if we bring in such amount, you will not get this kind of sentencing and so forth and so on. But in the situation that we found ourselves, even if we decided that we're going to, I'm talking about the accused persons, they were even going to refund the entire amount, the judge will still go ahead and sentence them. So what benefits that to me? If indeed I'm accused of having stolen your money and I give you that money, you still have the right to sentence me for a term that I do not know. Nobody's going to do that. So anytime next week, the appeal will come out. And I can also assure you that it will be coupled with an application for bail pending the determination of the substantive appeal. That much I can tell you. I can assure you that based on the discussions that I have, don't forget I'm only a lawyer. We always act on instructions, and therefore what I'm telling you is what has transpired between me as a lawyer and my client. And I'm telling you on authority that based on the instructions that I've received after the sentencing, we've been empowered or ordered or directed or instructed to file an appeal. And the appeal will be against the conviction.